I guess probably good to introduce ourselves before we get into it very quickly. So my name's Mike. I have worked in the sector for 20 years or so, and more recently have been doing casework. I'm not legally trained. I'm not a solicitor, but it's all right because most housing officers aren't solicitors, and that's kind of who you're up against. And my job for 10 years has been to apply, or get council to apply the law fairly to homeless people to get them housed. And in the last sort of, well, I don't know, 8 years now, I've been delivering training. So I'm trying to give people the information they need to know to use the law to get people housed. There's a quote from one of the cases we're going to talk about today, which makes the point where it's a judge speaking. He says, housing law is there to house people, not, kind of avoid housing people. So that is the whole spirit of the law, with some exceptions around intentional homelessness being one of them. So that's myself. Will, who are you? What's your background and everything?
Hello, I'm Will. I'm a housing solicitor, and I'm based in Southeast London. And I also well, I work all over the place because I can do most of the work remotely now. And I've been doing housing law since the early 90s now. And I think I specialize in homelessness and sort of looking at the difficult cases, which are very worrying at the time, but they're the most interesting ones where you think, oh dear, this case is falling between the cracks. Or what do you do if, for instance, what do you do if you can't challenge a decision that someone's intentionally homeless and they're in priority need? But I'll maybe come on to that later.
Yeah, cool. Thanks, Will. And Will's very modest. Will, I'd imagine Will's got thousands of people housed through his work. I'd love to know actually what the figure is, Will. But yeah, you kind of just sort of beaver away and just apply this stuff day in, day out. So yeah, yeah, it's just amazing to have you here, really, and kind of helping out. Just kind of give some extra detail. I'm not going to obviously not get everyone else to kind of give their intros, but it might be nice to hear in the chat whereabouts you're from, what your remit is. So yeah, kind of again, that's not going to be part of the recording. So if you just want to say whereabouts in the country you're from, what your role might be. If you've got any particular questions about intentional homelessness now, that's probably not a bad point to use the chat to ask them. And I'll try and tie them in with the slides as we go, because it's just good to know, as I say, who else is here really. So whilst you're doing that, let's get started. So big picture for a little bit before we get into the nitty gritty of it. The reason we have intentional homelessness as a concept is that there's a couple of principles that run through the law. One is that effectively people are expected, wherever possible, to take responsibility for their own accommodation. So I'm just reading the kind of second sentence here. Wherever possible, people should take responsibility for their accommodation needs and not behave in a way which might lead to the loss of their accommodation. So that's kind of the first principle, I guess. And the other is that without intentional homelessness, it would be very easy to effectively queue jump the list for social housing. Now, there's lots of kind of caveats with that these days because social housing is not guaranteed anyway. But if there was no such concept of intentional homelessness, there would be nothing stopping someone, particularly with someone with kids where they're going to be automatically in priority needs, from just literally abandoning their property, approaching the council and, kind of getting housed very quickly that way. So that's really where it's coming from. It does get incredibly nuanced at parts, I have to say. And it's interesting that a lot of these cases date back to the 80s and 90s. So I think Will would probably agree with this. I know Will said it a number of times. Intentional homeless decisions tend to be less frequent or less kind of common in the kind of casework that people are doing. So, certainly in my experience, the majority of questions that come in on the live stream, for example, tend to be about priority need and suitability of accommodation. Intentional homelessness seems to be less kind of, I don't know, less kind of invoked, potentially because the Homelessness Reduction Act pushes the whole lot of it down the road a little bit after the relief duty. But it's still very important. This is an excerpt from a case I worked in back in from 2018. That's when I first met her. This was a mum and 5 kids who was found intentionally homeless by Bedford Borough Council, and this started a 7-year period of them basically just being either homeless in temporary accommodation or in unsuitable, unaffordable private rented. They only got housed properly about a year ago. And the damage that this single sentence here, after careful consideration, the council has determined that you're eligible for assistance homeless or threatened homelessness in priority and that you are intentionally homeless, has caused incalculable harm for that family. Now, they weren't intentionally homeless from day one. It should have been obvious. But these kind of decisions that are just rattled off, they're just templates. These define people's lives. So that's kind of why, we want to kind of talk about it today. It's not just some boring little principle that's in law somewhere. This is actually going to affect, thousands and thousands of people every year. So that's kind of, yeah, that's the kind of basis of it. And I guess what we're going to see in the case law, because a lot of these cases do come from the 80s and 90s, you'll notice a bit of a shift in the principles or some of the principles underpinning it. I've put some cases on the screen now. I might just kind of go through them briefly in a minute, but certainly judges are saying things in these cases in the 80s which, would be frowned upon now. Let's put it like that. So, for example, this one here, Swansea XP John, the tenant's failure to remove a partner who was alcohol dependent and antisocial, despite him being larger and younger than her, was seen to make her intentionally homeless. Now, a situation like that these days, I think, would raise questions of domestic abuse and whether a smaller, older woman should be expected to kick out their larger, larger, younger, presumably stronger husband. We see it elsewhere as well. This case at the bottom here, Tower Hamlets XP Katoon, reference to the head of the household. Again, this is not concept I think would be kind of really advanced these days, but we still see it. And until someone, kind of brings in some new precedents, well, I guess we're going to continue to see it for some time. Before we get into, again, the detail, I just want to throw these things out there now, because in one sense, we're here to bust myths. These are probably the most prevalent myths that I see. So if we just get these out of the way, and if you get bored or whatever, you could just drop out and at least you've learned something. So firstly, intentional homelessness is not relevant to the initial duties in the homeless application. So both sections 184, which is the duty to accept an application, where an applicant asks for help with housing and gives the council reason to believe that they might be homeless or threatened with homelessness, does not mention intentional homelessness at all. So you can be definitely intentionally homeless. You can still make an application. And then the interim accommodation duty, section 108, where there is reason to believe that someone might be homeless, might be eligible, and might have a priority need, again, does not take intentional homelessness into account at all, doesn't take local connection into account either. So that's just kind of getting that out of the way. There is still plenty of reason, it's definitely worthwhile to make a homeless application, even if you think you are definitely intentionally homeless, because there is other assistance that would be available to you that has designed to be there, basically. So, yeah, that's the first thing. Secondly, it's also not relevant to the prevention and relief duties in the sense that they will still be triggered even if you are intentionally homeless. I appreciate that being intentionally homeless might reduce your options down the line, so it would affect the relief duty in that way, because the personalised housing plan would be sensible to take that into account, that you are likely going to be found intentionally homeless. But it doesn't stop those duties from kicking in the first place, and those duties kick in where the council is satisfied you are homeless and satisfied you are eligible for assistance for relief duty, and for prevention duty is satisfied you are threatened with homelessness and eligible. And thirdly, there is a housing duty to people who are homeless, eligible, and in priority need, but they're also intentionally homeless. So section 190 kicks in at that point. And in practice, that means that if someone is approaching a council, they're in priority needs, but they're intentionally homeless, they're eligible, they're homeless, everything, they are still going to be housed for something like 3 months. The timescale is not set in stone. It's going to be at least the relief period, which is 56 days, plus another 2 or 4 weeks, plus a bit of time just for the council kind of delaying inquiries and stuff like that as well sometimes. That is designed to be there to give people, time to work out what other options they might have. Fourthly, there is no such thing as an intentionally homeless family. We're going to talk about this later on. There's this fancy word called acquiescence, which basically means that where you have multiple adults in a household, or technically even, I guess, over 16-year-olds, although I'm not going to put my name to that. Certainly when you've got multiple adults in a household, each one can apply in their own name and effectively would need to be considered in their own right, despite the fact there is, a higher likelihood they'll be found intentionally homeless, which again we'll come back to. And then finally on this one, it's not for the applicant to prove that they are not intentionally homeless. It's for the council to be satisfied that they are. Again, there's this kind of exception of acquiescence, which we'll talk about. But many people who approach councils, they feel like they're, getting the third degree. They feel like it's just, the way the inquiries are conducted are not fair. But in the case of intentional homelessness, legally, it's for the council to satisfy themselves that the person is intentionally homeless, not the applicant's job to prove that they're not. And there's a whole process that needs to happen to make sure that's kind of fair and is given people opportunity to actually, kind of put their position across. And to state the obvious, there are a number of reasons why intentional decisions are particularly damaging in a different way from non-priority decisions, because with non-priority decisions, You're often going to be relying on vulnerability. It's often going to be something which is not clear cut. And it's generally not difficult to do a bit of digging and find fresh information, new information that would be able to trigger a fresh application fairly easily. Whereas with intentional homeless decisions, if the applicant doesn't challenge it within the first 21 days of receiving the decision, it can then make things very difficult, more difficult than a non-priority decision would. So there are some things you can do. We'll talk about that at the end of the slides. But as I say, it's something to bear in mind. So if you are supporting homeless people and one of your clients gets given an intentional decision, you need to basically make sure you're getting on it and challenging it ASAP. Make sure you're putting something in. In my experience, there are very few people who are actually intentionally homeless. Many more people will be found intentionally homeless than actually are. That's again because of the sort of the default sort of injustice built into the system. Secondly, on this one, it doesn't stop you being on the housing register. You still get reasonable preference if you're intentionally homeless, but it probably gives you the lowest possible band, which in many places in the country gives you zero chance of getting a social housing. So it has kind of a wider negative impact, particularly potentially. And finally, support accommodation. So when someone is found to be intentionally homeless, often if they're single homeless, their next next kind of best thing is going to be support accommodation. Now, if you know me, you know I'm pretty critical about the supported housing model in general, but in particular because supported accommodation has relatively little security of tenure, and it's very easy to evict people for breaking rules or whatever. And then that kind of means that people are then put out there definitely intentionally homeless the second time if they weren't the first. When I was researching the slides, I came across a judgment from the 80s, might even been like 79, because I think this was enacted in like 1977. And there was a judge, I presume, who described intentional homelessness as a semantic nightmare because the way it's constructed just makes it incredibly convoluted, and that can be that can go either way. That can be in the applicant's favour or in the council's favour. It just depends what the situation is. But so we're going to try and unpick it. Basically, we're going to start by looking at breaking the chain of causation. That's a term you might have heard before. And also, in order to do that, what does settled accommodation actually mean? We're then going to look at deliberate acts on settled accommodation again, because just because of the way that the legislation is constructed, it comes back again. We're going to look at acquiescence, and we're going to look at fresh applications, and hopefully that will all be done by 5 o'clock. So that gives you an idea where we're going with this. Breaking the chain of causation, as I say, it's kind of thrown around quite a lot. When you are when a council assesses whether someone is intentionally homeless, the very first question they need to really establish is where was that person's last settled accommodation? Because any other type of accommodation doesn't matter. So previous settled accommodation before the last settled accommodation is irrelevant. More recent temporary accommodation, unsettled accommodation, let's use that word, that's not relevant either. Unfortunately, the term settled accommodation is kind of not not particularly well set out in law. There's certainly some grey areas which can go both ways. So there are, generally speaking, obtaining settled accommodation. Let's go back a step. If you're found intentionally homeless, the single best way to get unintentionally homeless is to secure settled accommodation and then lose it again. That might seem like a weird way of saying it, but that's kind of how it works in practice. So that's the main way that you're going to essentially no longer be intentionally homeless. And then, let's say, for example, you were evicted from your property because you trashed it and there was no good reason for trashing it, which there probably wouldn't be. You then secure another assured short hold tenancy. It seems to be going on indefinitely. And then a few years later, the landlord evicts you under Section 21, so a no-fault eviction. In that situation, you are probably not going to be intentionally homeless anymore. There are obviously little caveats even with that. So securing settled accommodation is kind of your best way of doing it there. Now, there are other ways in which you can trigger a fresh application that kind of don't involve securing settled accommodation. I'm probably not going to go into that in much detail because it just gets a bit of a rabbit warren. We will come back to it with a case at the end called Ivory v. Well and Hatfield. Now, as I say in the slide here, secondly, given that the burden of proof lies with the council, in the real world, it gets more and more difficult to find someone intentionally homeless from further and further back in time, because it might be you haven't got the landlord's details, you can't make inquiries from the landlord. It might be that other kind of sources of information have sort of, evaporated with time. But in theory, just to make this point, you can, in theory, be intentionally homeless for the rest of your life. That is legally possible, although probably quite unlikely. And so, I mean, if you ask me what would I want to change about the law, I would probably want to have something in there which puts a time limit to intentional homelessness in general. Because it seems very harsh to be using a situation that happened 10 years ago against someone now, given that in the interim that probably they've served their time, if nothing else, so to speak. They've probably had enough suffering to kind of teach them to do better next time, if that's not a clumsy way of saying it. The kinds of accommodation that you would need to secure to break the chain of causation, to no longer be intentionally homeless. um it seems a bit miserable, really. So there's these cases here. I'm going to go through them briefly in turn. So Brent XP Awua makes the point that you can be found intentionally homeless from temporary accommodation that's been provided under Section 193. So Section 193 is the main housing duty. It's owed to people who are homeless eligible, in priority need, not intentionally homeless, and the local connection criteria has been kind of taken care of in one way or another. But yeah, and so you might still be in a very kind of unpleasant accommodation, but because in theory there is a guarantee of a settled accommodation at the end of it, whether it be social housing or long-term private rented accommodation, if you are to lose Section 193 temporary accommodation, you can absolutely be found intentionally homeless from it. And there's actually a case earlier this year called Beach v South Hams, where this guy he was found, owed the main duty, so he's owed the main housing duty, Section 193. He was placed in a hotel, which, among other things, didn't take pets, and he had a dog, so he didn't basically continue to reside there. And his failure to occupy the accommodation meant that he was then found intentionally homeless. So he was basically, the main duty was ended, and he was found intentionally homeless. Other bits and pieces that might kick in here. So Moran v Manchester made the point that refuge accommodation is not reasonable to continue to occupy, so cannot be settled. And this also applies to night shelters and sweat provision as well. The reason I'm putting this in here is to make the point that you cannot be found. I may be kind of mixing the slides up slightly. I might probably come with a better logical order for these, but I'm hoping this still makes sense. But you cannot be found intentionally homeless from refuge type accommodation because it isn't settled. So if you fled domestic abuse, for example, and moved into a refuge, and then you got kicked out from the refuge because you broke the rules or something, the loss of the refuge is not relevant. The council would need to look back to the last accommodation you had, which would probably be the accommodation you fled domestic abuse from, and ask the question: are you intentionally homeless from that address? So again, I've seen many times when people get kicked out of the night shelter or whatever, and they get told, you're intentionally homeless, and there's no point making a homeless application, when really that is just not even kicked in yet. That's not an actual consideration. The council always has to go back to that last settled accommodation. And this case, Belisle v Westminster, probably gives the principle quite well. So a period of occupation which is likely to continue for a significant or indefinite period is likely to be regarded as settled. Now, bear that in mind, because if we go to the next slide, I might come back to that Belisle case because it's a good one. But we've got these examples here where accommodation would not be considered settled. So Gilby v Westminster, where this person was sofa surfing in the same property for 3 years, that wasn't settled. Huda v Redbridge, a nightly lease for 4 years wasn't settled. Knight v Vale Royal Borough Council, I guess that is, where I think this lady moved into an assured short hold tenancy. But from day one, that landlord has said to her, I'm going to be selling this property in 6 months, so you're only going to live here, kind of for 6 months or whatever it was, 6 months plus the eviction period. And that basically meant that it was not settled because it didn't have that indefinite kind of nature to the stay there. Mohammed v Westminster, where unaffordable, overcrowded accommodation was not settled. And if we just go, kind of the question, some of these questions I'll answer straight away because they kind of directly relate to the slide. So, what is considered significant period of time to be considered settled? That's a very good question. It's not. It's not kind of the law, for whatever reason, doesn't give us that amount of clarity. I guess the reason the law doesn't give clarity is that it always wants councils to assess the facts based on the individual circumstances. So it doesn't want to have specific kind of timescales or whatever. If we go back to Belisle, I think this is kind of key. So significant or indefinite period. I guess that what means is that when you take up that accommodation, there is no set end point that's set out. That's kind of what I think it would mean. But if the landlord said, I'm going to sell it in 15 years, I'm sure that would still, that would kind of class as settled. So Whilst it's a great question, I don't know that the law actually gives us that kind of level of, kind of framework to work within. It's kind of, yeah, each case needs to be based on the facts. Now, this is relevant to things like supported accommodation, because supported accommodation, yeah, traditional supported accommodation, you can stay there up to 2 years. And there's certainly been cases where someone stayed much less than 2 years, and it certainly hasn't been settled. In most most registered supported accommodation providers, there is some kind of exit strategy from that supported accommodation. So let's say, the stay is on paper supposed to be 2 years, but after 6 months you will get band B on the housing register. Then, because I guess there's that kind of, like, there's that route into settled accommodation, I would say that, yeah, there's a good argument that supported accommodation often will be settled. What you often see with homeless applications is that councils will tend to have that kind of, they kind of play it both ways. So if it suits them, they'll consider the 3 month stay in supported accommodation was settled because it makes it easy to make an intentional decision. Whereas other times they would potentially disregard that and then go back to the previous accommodation before they moved into supported. I hope that makes sense. It's not, yeah, it is. I don't know if I could do a better job of explaining that, really. But yeah, there's not a set time scale. It would be nice if there was, I think.
Could I just
Yeah,
jump in there?
100%.
I think generally you'll find that with terms like significant, the courts are very reluctant to sort of apply a scientific sort of formula to working that out because it isn't a term of precise term and it's not intended to be. And so I think you'd interpret it as meaning it as long as you don't have to leave in the foreseeable future. But another example I was thinking of a word which is frustrating and it's not defined is the definition of a disability for the purposes of the Equality Act 2010 is where you've got a medical condition which has an adverse effect on your ability to carry out day-to-day activities. But within the definition, it says it has to be a long-term problem. Now, you might think long-term there means, years, but it means the actual legal meaning is anything more than fleeting. So if it's like, but that's not a common sense meaning, but the courts are just really reluctant to get tied down. So they basically say, well, long term just means it's not here today, gone tomorrow. And just like significant here means it's you're not about to leave. So it can be considered accommodation. So sorry if that's a bit of a waffle.
No, it's all good. I mean, I think if we go back to the Moran v Manchester case, so this was, the question of, is a women's refuge accommodation in which you're not homeless, as in, is it reasonable to continue to occupy? Essentially, that case, I mean, again, I've not read it for a long time, but basically that case made the point that whilst a refuge would be considered accommodation, because you can't occupy it indefinitely, because of the nature of a refuge is it's generally, 3 or 6 months or whatever, then it would not have that long-term nature. So I think, I'm not saying that answers the question in the chat, but I think that kind of maybe just kind of gives us another idea of this kind of idea of indefinite. It just means that there is no sort of set endpoint from the start. It's kind of about, what was that person's understanding. So if we go back to the Nightview Vale Royal Borough Council, where it is, um, the fact is that the tenant, so Miss Knight, knew from day one. So she entered into that tenancy knowing that it was only going to be there for 6 months, and that was kind of the opposite thing. Now, if she kind of moved in thinking, okay, this is going to be a rolling tenancy, it could be could last for years, and then the landlord happened to evict her after 6 months, then that's probably going to be a different answer. So, yeah, good question. Again, I'm not even sure if we still haven't actually answered it yet, but I'm hoping that gives you some sort of clue about it. So that's settled accommodation. So just to kind of reflect on that, you need to look back to your last settled accommodation in order to establish, whether that person's intentionally homeless, and obtaining some kind of settled accommodation that essentially resets the test. Then you don't have a new property or a new address to assess whether that person is intentionally homeless from. So that brings us to the actual definition of intentional homelessness itself. We get this from 9.7 of the Code of Guidance, which in itself comes from Section 191, subsection 1 of the Housing Act 1996, which says that, and by the way, obviously this is me highlighting it just to make the point. I'm just going to obviously kind of talk about it a bit more in a minute. So Section 191, subsection 1 provides that a person becomes homeless intentionally if all of the following apply. Firstly, A, they deliberately do or fail to do anything in consequence of which they cease to occupy accommodation, and the accommodation is available for occupation, and it would have been reasonable for them to continue to occupy the accommodation. So B and C kind of mirror the Section 175 definition of homelessness. So Section 175, and I will go into a slight bit of detail here because it's probably useful to frame the next bit. Section 175 gives three situations where you are homeless now. So one is if you have nowhere with a legal right to occupy. But secondly is you have accommodation, but it's not available for your occupation, which kind of ties in with this bit here. And then thirdly, you have accommodation, but it's not reasonable to continue to occupy for a number of different reasons, things like being at risk of domestic abuse, not being able to afford it, unsuitability of medical conditions, severe disrepair, kind of health effects from damp and mold, those kind of things. So this is kind of often going to be the reason why someone might have done something deliberate, but they still actually wouldn't be intentionally homeless because all three of these criteria have to apply. And you'll also notice as you go through that A and C overlap quite a lot. It's actually quite difficult to kind of distill them out from each other. I'll give an example where it says in a little bit that if someone hasn't paid the rent, but it's because of a genuine financial issue caused by benefit delays or something like that, then it would not be considered deliberate. But you'd also probably have a situation potentially there where it would also not be reasonable to continue to occupy because it was not affordable. So again, there's that overlap which kind of makes it slightly, I don't know if it makes it kind of more complicated than it probably needs to be. So again, just kind of set us up for this section. 9.16, the Code of Guidance states that homelessness to be intentional, the act or omission that led to the loss of accommodation must have been deliberate, and applicants must always be given opportunity to explain such behaviour. An act or omission should not generally be treated as deliberate, even where deliberately carried out, if it is forced upon the applicant through no fault of their own. So something like fleeing domestic abuse would be a good example. Maybe also things like cuckooing would be another good example there. Moreover, an act or omission made in good faith where someone is genuinely ignorant of relevant fact must not be treated as deliberate. Now, this concept of good faith within the legislation is one of the most complicated bits, and it's not something I go into a huge amount of detail here because it's quite rare that it really we really sort of see it in action, certainly in my experience anyway. We will kind of touch on it, but it's not something I go in particularly into detail here in the slides. So if we start with things that would probably be deliberate acts. 9.20, the Code of Guidance, helpfully lists a number of situations. So again, I'm just going to whittle through these because this is probably less interesting than the other bits that follow it. So firstly, if someone chooses to sell their home in circumstances where they're under no risk of losing it. Secondly, has lost their home because of willful and persistent refusal to pay rent or mortgage costs. Thirdly, C, could have been said to have significantly neglected their affairs, having disregarded sound advice from qualified people. And then goes to the next slide. Fourthly, D, voluntarily surrenders adequate accommodation in this country or abroad, which would have been reasonable for them to continue to occupy. You actually see quite a few cases where someone's abandoned their home in their home country, come to this country in search of employment or something. And they kind of the accommodation in their home country is the last settled accommodation that the assessment will take place in regard to. Fifthly, E is evicted because of their antisocial behaviour, nuisance to neighbours or harassment. Sixthly, is evicted because of violence or threats of violence or abuse by them towards another person. And finally, G, leaves a job with tied accommodation and circumstances indicate that it would have been reasonable for them to continue in their employment and reasonable to continue to occupy the accommodation. So you might see examples here where, I remember working with a guy, he was a pub landlord and he basically was caught stealing from the till, and so lost his job and simultaneously lost his accommodation as well and was intentionally homeless. So that kind of situation would come into that final one. There's a few other bits and pieces which I've just kind of picked out from legislation, which again, I'm hoping, it might just kind of have wider relevance. So this one, Hammersmith and Fulham XPP, was an interesting one. I'm not quite sure what they were doing. This family lived in Northern Ireland, and they were acting in a way which drew the attention of the IRA, and the IRA didn't like it, and so they basically threatened to kill them. So they then came to Hammersmith and Fulham, and I don't know if it seems harsh or not. I mean, the reason for them being homeless was the death threats, but Hammersmith and Fulham were found to rationally or kind of been reasonable to conclude that because the death threats arose from their own antisocial behaviour, that it was their behaviour that got them evicted and therefore found intentionally homeless. The reason I put this in here is that you may see cases where someone has to flee accommodation because of a drug debt or something like that. They've ripped off some local dealers or something and they're now running off. Where in theory, if the council had access to that level of information, they may well be legitimately found intentionally homeless. The second one here, Denton v Southwark, was probably quite common occurrence. Which again, it's weird how case law works. In this case, it specifically says, well, the judge specifically said, don't you shouldn't infer general principles to similar situations. And yet, I see this case mentioned in various ways, specifically kind of giving us kind of inferring general principles more widely. So I've included it, and effectively in this case, this young guy was living with his mum. He was using drugs and kind of generally being rude, and his mum kicked him out, and he was found to be intentionally homeless. Although obviously the nature of living with your family is different from having a tenancy. In this situation, the fact his behaviour had been reasonably led to his mum kicking him out was enough to show he was intentionally homeless. This case here is interesting, Bratton v Croydon, where this family were evicted through the Section 21 process, the no-fault process, and they actually had less rent arrears than a single month's rent. I assume they accrued it over several months, and the landlord basically, kind of had obviously very little patience for it and proceeded to evict them. They were found intentionally homeless, which I think is quite harsh, and it kind of again maybe goes against some of those ideas that we saw kind of a bit further up. This kind of idea here, have lost their home because of willful and persistent refusal to pay rent. I'm not quite sure how long they willfully and persistently to refuse to pay rent, but it wasn't very long, and they were still found intentionally homeless. And then fourth on this one, mentioned the Sheffield. You see this come up quite a lot, and it's surprising how many people I train who think that people who go to prison and therefore lose accommodation aren't intentionally homeless. But they are, or they certainly can be. Again, you'd have to apply the three-part test of 9.7 of the guidance, because remember, you might deliberately go, do something that results in you going to prison. You still have to assess, particularly whether it had been reasonable to continue to occupy that accommodation. And I haven't actually said it yet. Intentional homelessness does not mean that you intend to be homeless. That's not the way the law is trying to say it. What it's basically saying is that you're intentionally homeless if you did something intentionally which you should have realized could result in you being homeless. So, question just coming into the chat here. So, what happens if someone's mental health issues lead to losing their accommodation or job, but they haven't received a medical assessment following a breakdown? Can this situation still be considered intentional homelessness? So, really good question. I think there's a legal answer to this and there's a practical answer. The legal answer is you councils don't need they don't need to see a particular diagnosis or particular medical assessment in order to take the applicant's word. So I would say that legally, if an applicant said, look, I had a mental health breakdown and here's kind of maybe some evidence that isn't a medical letter assessing it, then a council should certainly take that seriously. In the real world, it really helps to have a medical assessment confirming something, someone's mental health is breaking down, for example. I don't know if that's something which you kind of have more to say about, given that this is probably, something which you see probably more often than I do. But I mean, in terms of kind of what level of evidence should be needed if someone is kind of saying that they lost their accommodation through mental health issues or kind of some other support issues.
Yeah, I wanted to actually say about this because this raises one of my things I often say on the live stream that the question here, can this situation still be considered intentional homeless? I'd say to you, I'd caution against thinking there is a yes or no answer to that because in reality, the council may try it on. If in doubt, they may try it on and make a negative decision and then leave it to the person to challenge it. So the question really is, can the council get away with it? Which is what you mean. And the answer is, well, not necessarily. If the person did have mental health problems, but even if they didn't have medical evidence, but there was other corroborating evidence, say, for instance, they lost the accommodation because they were seen behaving in a bizarre way, which would be consistent with the witnesses who say, he was showing signs of schizophrenia. You don't have to be a doctor to identify that. But I mean, in practice, you'd probably be able to get a medical report. So I would say definitely try and challenge it and get a medical report. But in the meantime, you wouldn't need to produce that straight away to raise the argument.
Cool,
So
thanks,
I'm
Will.
getting a lot of background noise at this end. I'm just going to try and cut it down.
That's cool. So non-deliberate acts, this is where, as personally as someone trying to get people housed, this is more useful. So this is kind of stuff I'm tend to be more interested in. Now, 9.17 in the Code of Guidance gives us 5 examples where an action should not be considered deliberate. And as I've kind of said already, the first one, A, it kind of overlaps with what we said already. So if the actual omission was non-payment of rent or mortgage costs which arose from financial difficulties which would be on the applicant's control, then they shouldn't be considered deliberate. And also, I would also argue there at that point that the accommodation may well not be reasonable to continue to occupy through unaffordability. So you kind of have it from, I don't know if you make the argument twice really, but you have it from both angles. But B, C, and D are kind of much more interesting. So B, the housing authority has a reason to believe the applicant is incapable of managing their affairs sorry, for example, by reason of age, mental illness, and disability. And I've inserted there both old and young. So, um, yeah, I think when most people read that sentence, they think of old age, but the guidance does specifically talk, or the case law does specifically talk about young age as well. And again, there's never any sort of hard and fast rule on this. Someone who is younger than 16 may well be mature enough to have this kind of capacity needed to manage their affairs. But equally, particularly where you've got a kid who's been traumatized by whatever, then it might take them longer to mature and longer to kind of understand the consequences of their actions. So within this kind of ambit of the law, there's kind of mention, for example, if you've got like someone in under children's services should be kind of approached for information which would give an idea of whether that person was able to manage their affairs. And the same would apply for a kid who'd been traumatized and who was not under children's services. So it's not just specific to care leavers or whatever. As a slight aside here as well, not that this is what we're here to talk about today, but certainly some councils badly misapply the idea of mental capacity to making homes applications, because the law is you need mental capacity to make a homeless application. Now, it's never actually quite clear what you need capacity to do, because hardly anyone understands the ins and outs of a tenancy. But I think generally speaking, if you understand, if you have capacity to instruct a council that you want to make an application, that you have some kind of the cognitive ability needed to give, say where where you wish to live, what kind of accommodation you might need, that you need to pay money to maintain the rent, that sort of thing, then that should be what we're talking about. And I've seen councils, they see that someone has previously had some kind of period where they lacked capacity and jump to the conclusion that they don't have capacity to make a homeless application now. That's completely illegitimate. Mental capacity fluctuates. It's always time decision specific. So in that situation, although the council would probably want to be mindful and kind of consider doing a capacity assessment, just because they might not have had capacity recently doesn't mean they don't have capacity now to make an application and maintain a tenancy. So like this, you can often see this where someone, let's say, had a psychotic episode, they trashed their flat, kind of end up in hospital, but now they're better and now they're kind of recovering. That person absolutely can make a fresh application and potentially wouldn't be intentionally homeless, even though they trashed the flat and kind of the landlord was probably very reasonable to evict them. Thirdly, C, the actual omission was the result of limited mental capacity or a temporary aberration or aberrations caused by mental illness, frailty, or an assessed substance misuse problem. Now, up until today, I did not know any case law that relates to this. For people who work with single homeless people, drug and alcohol issues and mental health problems are very prevalent. I'm not saying that every homeless person has got those issues, but there's obviously a correlation. And clearly, in many cases, people lose accommodation in part as a result of their drug and alcohol use. And I was surprised by the lack of case law on this, but I did find one case, which I'll come to in a minute. Just as an aside, if you're working with that client group, I think part of the reason there's not a lot of case law on this stuff is that people don't generally get supported to make applications and fight council decisions. So if you're working in a sector, I would say, you really want to be pushing, if you're working with people who are homeless, you want to be using homeless application as, yeah, if it's not route one, it's certainly a really kind of important issue to be, or kind of route to be going down, far more than other, kind of supported accommodation routes, in my opinion. Getting people housed through the homeless application process is far more successful. I've worked with people who are supposed to be unhousable, and yet once they were given suitable, safe accommodation, they never looked back, without, with little or no support as well. So, yeah, so just, I mean, I mentioned it, so I'll kind of go on briefly. I'm going to jump a couple of slides, but I'll come back to this. The case I'm talking about is, oh, where's it gone? It's called Kendall. I've lost it on the slides. Okay, I'll find it again in a minute. Basically, it's called Kendall v. I think it's Westminster from 2009. And basically, in that case, the lady had a long history of crack cocaine use. She, at some point, lost accommodation in about 2002, social housing tenancy. I think she spent a number of years kind of, sofa surfing and whatever, ends up in prison, comes out of prison. She's now abstinent and makes a homeless application, and makes the argument that, she lost her last accommodation because essentially of the chaos caused by her crack use. And Westminster, I'm pretty sure it was Westminster. The client was definitely called Kendall. She basically, won the argument, so to speak, because the council had not actually considered whether she'd lost that accommodation through, kind of this kind of thing. So I've certainly seen it in my own case. Like, I'll give this example on the training actually, where I worked with a guy who was alcohol dependent, had some other mental health issues as well, moved into the complex needs unit in the town. Within a short space of time, relapsed, got very, very drunk, urinated everywhere, got evicted for urinating everywhere, approached the council, was found intentionally homeless. And I used this section here to argue against intentionality, and got the decision overturned, got him the main duty. But up until I've seen this case today, I'd not seen the argument kind of applied to kind of, longer term drug and alcohol issues. So it's really welcome. And again, it's in the slide somewhere. I must have mixed something up somewhere. But yeah,
I found it in
fourthly,
legal action. I'll put a
what,
link to it on the task on the chat.
say that again, Will. Have
I
you got
found
it?
it on legal. I've been Googling for that judgment, but there's a
Yeah,
report of it in legal action. So
cool.
I'll attach that to the chat.
Yeah, nice one. I think Garden Court Chambers, they did something
I'll,
on it as well.
I'll keep looking.
Yeah, yeah, yeah. But no, yeah, yes, that'd be great. Because I think, yeah, to say that's a really important case. And I think, as I say, it applies to someone who's, it's not that they necessarily have like an acute period where they lost capacity because of their drug use. It's that kind of like longer term sort of chaos and kind of, fluctuating capacity and stuff that inhibits their ability to, to be a good tenant, for want of a better word. So, fourthly, D, the actual admission was made when the applicant was under duress. This would cover, cuckooing, domestic abuse as well. Yeah, basically where someone is kind of bullied or threatened into doing something, which then results in them losing their home. So it might be something like, someone gets cuckooed, the flat is then used for storing drugs or guns or whatever, and then they get evicted because of that, that those drugs on the premises or whatever. But actually, they wouldn't be found intentionally, or they shouldn't be. Interestingly, the law, if it hasn't already changed, it's about to change to make cuckooing a crime. So keep an eye out for that sort of stuff. I don't know too much about it yet. And then finally, imprudence or lack of foresight, blah, 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 good faith. As I say, I'm not going down this rabbit hole today of good faith, because I don't think it's worth the effort, quite frankly. And also, the case law is kind of weirdly sort of contradicting, because there was one case, for example, where someone left they handed their keys in. The landlord gave them Section 21, and they gave the keys back on the day that the Section 21 ended, and they were found intentionally homeless. And then there's other cases where the opposite's true, and I have no idea what the actual truth of the matter is. So yeah, we'll leave that for now. We haven't got time for it. Let's say that much. Oh yeah, and I've just found the slide I was talking about actually. So other situations, forget that one. So but this one here. So other situations where the person is not, or it shouldn't be considered a deliberate act. Now, this is kind of what, this is an infamous case. Nearly Legal reported on it. So if you're not following Nearly Legal, you need to get the newsletter, follow Giles Peaker on LinkedIn. Really amazing kind of like just summaries of cases that come up, include, not just homelessness, kind of a wide array of housing law. But he basically said this is the worst homeless application decision he'd ever seen. And it was Torbay Council. And in their decision, they basically said the following. So subsequently, You fail to occupy your room provided for you by housing options and have not returned. You understand from signing your tenancy agreement that you must occupy your room every night without prior consent from housing services. You have previously been advised and have received warning letters about how your actions and behaviours will result in the loss of temporary accommodation. Therefore, as you have again taken an overdose and have gone against the assistance and guidance from mental health, you have been asked to leave the accommodation. So this person was in hospital, if I understand correctly, recovering from an overdose, and they tried to say that that was a deliberate act. That disregarding the advice from mental health team was enough to kind of qualify this person as being intentionally homeless. So yeah, this stuff does happen out there. I've not seen anything quite that bad myself, but other bits and pieces that would mean that you're not, shouldn't be considered deliberate acts. Couple of ones here about getting pregnant. So I think certainly the BT cases from the 80s. In that case, this family was already in overcrowded accommodation, and they decided to have another baby. And Eastleigh Borough Council said, that's an intentional act, that's a deliberate act. You're intentionally homeless. And Justice Wolf in the case said a family cannot become intentionally homeless simply because they've chosen to have additional children. And then similarly, this Tower Hamlets XP Hock, Sir Blom Cooper QC said that the decision-making process is against a similar situation about getting pregnant and increasing the size of the family. The decision-making process had been tainted by the value judgments of the council's officer, which had no place in the statutory scheme. So sometimes good just kind of reflect on that sort of stuff, that housing officers' jobs are certainly very difficult, but that part of the difficulty of their job is they are specifically not allowed to bring in their own particular judgment, kind of moral kind of judgments or moral frameworks to these decisions. They are supposed to just apply the law. And intentional homelessness is probably a good example of this, where actually applying the law as it's worded kind of results in some rather unusual and kind of probably unintended consequences. And yet that's the way the law works. You follow the law basically. Yeah, this is the kennel. Yeah, this is the kennel case I was just talking about. And then this is kind of like, again, some cases here which are kind of grey area. So Hijazi v Kensington. So evidence of inability to manage affairs needs to relate to the relevant time. So this guy had fluctuating capacity, but when he lost capacity was a different time from when he did whatever he did that got him evicted. Wirral XP Bell, you can be vulnerable and still able to manage your affairs. So this is kind of the idea that there is obviously crossover here. So someone who is unable to manage their affairs is probably going to be vulnerable and therefore in priority need. But that does not mean that they are always going to happen at the same time. So there will be plenty of people who are vulnerable. They hit that vulnerability threshold, and yet they are nowhere near being at a state where they can't manage their affairs. So one doesn't equal the other. A GB v Southwark, surrendering keys when the landlord told her to was an act in good faith. So it's not intentional homeless. That's kind of, I mentioned before. There is a case that goes the opposite way though, so I don't really know what the truth of the matter is. Where there is evidence that the tenant has received bad advice, or lack of evidence that they have received good advice, can potentially kind of save the day. So in this case, obviously she was given a Section 21 notice. The council didn't tell her that she could remain in occupation, and therefore, that the fact that she then left basically was not used against her. Interesting kind of area as well, because of the kind of the whole way that homelessness takes place in that eviction process, and how council should not be telling people to wait until the bailiff comes. So yeah, there's a bit of a weird sort of tension there. So that, just again, pause briefly just to say that we've just kind of covered that, or we've kind of touched on that idea of deliberate and non-deliberate acts. Don't want to use the word accidental because it's probably gives you the wrong impression. But yeah, so we kind of talked about this idea of deliberate. So in fact, if I go back to 9.7 again of the Code of Guidance, going back to the definition, the legal definition of intentional homelessness, there needs to have been a deliberate act. But as I've said already, there is also this overlap between the kind of A and C. So we'll now talk about reasonable to continue to occupy, because if the accommodation you've lost, if the settled accommodation you lost was not reasonable to continue to occupy, then you cannot be found intentionally homeless. And this can actually give rise to some rather unexpected consequences. So, for example, let's say I punched my landlord in the face and went to prison, and lost the accommodation, obviously. That does not necessarily mean I'm intentionally homeless. The council would still need to look at, was that accommodation reasonable to continue to occupy? And if the answer was no, because the damp and mold was at such a level that it was causing health issues for one of my family, then it wouldn't be reasonable to continue to occupy. Therefore, you can't be found intentionally homeless. So yeah, so you can kind of end up with some quite distasteful results from the way this works, but it is what it is. Again, just kind of some highlights here. So yeah, and I'm not sure if I just said it. The phrase reasonable to continue to occupy is exactly the same wording that we see in section 175, the definition of homelessness itself. So you are homeless if you have accommodation, but it's not reasonable to continue to occupy. If it's not reasonable to continue to occupy, then you cannot be found intentionally homeless. So it's kind of two sides of the same coin. And in fact, some of our, most important cases about things like affordability, like Samuels v. Birmingham, in my experience, I use that more to show someone's homeless when actually it's actually an intentional homelessness decision. It's a case about intentional homelessness, because the question was it reasonable for Miss Samuels to live in that accommodation where she was essentially having to choose between paying the rent and feeding her kids? And she ultimately she wasn't found intentionally homeless because it wasn't reasonable to continue to occupy. So yeah, common kind of things you're going to see here: domestic abuse. So accommodation that is where you're probably going to continue to be abused. You're homeless, and therefore you cannot be found intentionally homeless. That also applies to so-called non-domestic abuse, so abuse which is coming from someone outside of that family kind of setting, things like cuckooing and hate crime. Again, you might be getting cuckooed and you don't pay the rent, and you kind of spend the money on something else and whatever else, but you shouldn't be found intentionally homeless because the accommodation wasn't reasonable to continue to occupy. If you're working in a sector, one of the best things you can do here is be really hot on safeguarding alerts and stuff like that. So I work with a lot of people who will report a situation like this, and my first question is, have you made a safeguarding alert about this? Because it definitely qualifies, and they haven't yet. But if you make a safeguarding alert, a bunch of stuff happens with adult services. Some of that is then going to help you, kind of potentially evidence your case. So yeah, certainly that's come in handy quite a few times. Just for the benefit of the recording, the question is, can you only argue this when the rent has been put up? The answer is no. You can argue at any time, because there'll be other situations where the circumstances change that result in the same action. So let's say, for example, someone loses their job and therefore their income is less, whether actually the rent's not gone up, that would absolutely apply. But also, basically a lot of people have to resort to moving into accommodation they know is unaffordable. That doesn't change the way this works. So yeah, so they would still, you still be able to make that argument. Again, me and Will have been talking about for a long time, doing a video about affordability. Unfortunately, the case law is unhelpfully muddy about this, because although the Samuels v. Birmingham case was a great case, it was brilliant, there was a subsequent change in the Homelessness Code of Guidance wording, which has basically undermined some of it. And I'm certainly don't know where we're at with it now. Thirdly, I think the law is going to change in some of these ways. There's a case called Moncada, which I think was like 1997. I think they're married couple. The guy commits a crime, goes to prison. Whilst he's in prison, his wife, they separate. His wife forms a relationship with a new guy, moves the new guy into his home. Mr. Moncada comes out of prison and he's like, I can't live in my marital home with my wife, my estranged wife and her new partner. And essentially the judge says, yeah, you can. Yeah, the judge basically said it is reasonable for you to occupy that accommodation. Yeah, I think these days that would be screaming like, risk of abuse, risk of just some pretty bad stuff happening. But that is the current case on it. So the reason I kind of talk about this case is that where you've got relationship breakdown, which is, amicable, as in there's a lack of domestic abuse, or there's an absence of lack of domestic abuse, then that would not make it unreasonable to continue to occupy. So kind of mentioned unaffordability there, and also severe disrepair. So again, this is another reason why it might be unreasonable to continue to occupy, where you've got things like damp and mold, which are so bad that they are causing health issues to arise in household members. That would not be reasonable to continue to occupy the accommodation. So they'd also be homeless if they were still there, but they couldn't be found intentionally homeless from leaving it. Other bits and pieces. So yeah, again, I keep seeing cases in London, or like I keep training people in London where they're being told by housing officers that people who are sofa surfing are not homeless, and therefore they're just kind of getting sent away. Now, if someone is truly sofa surfing, they absolutely are homeless. So it's not reasonable to continue to occupy your friend's flat on a sofa. That's not that's just not going to count. Severe overcrowding. Yeah, these are all the kind of things you see with this idea of reasonable to continue to occupy. Interestingly, this last one, so Kensington XP Ben Al Mabrook, where I say it's interesting. I think this probably speaks to a more kind of broadly applicable principle. So in that case, it was deemed to be reasonable to continue to occupy a property with inadequate fire safety as the council was making the landlord improve it. So this was a guy who basically left accommodation because he said it's not safe, and he was found in tenancy homeless. So it was deemed to be reasonable to occupy because the landlord was essentially doing something to fix this, fix the issues. So it's not an uncommon situation where people you are coming to get support, and they are very worried about the condition of their property. It's horrible to kind of give this advice, but the advice I think has to be, or the suggestion should be to remain in the accommodation and pursue the fire safety issues with the council and get the council to basically make the landlord fix it. I appreciate, post Grenfell, that's particularly worrying if you're living in a high-rise block, but that appears to be where we're at with the law. I mean, this intentional homelessness and domestic abuse. This is an excerpt from the records, the council records of Bedford. It was the single easiest compensation claim I've ever made, because when I did the subject access request, this was a lady who's fleeing abuse. When I did the subject access request, the very first chronological entry on the system was, it basically said the client approached Bedford Borough Council and stated that she's experiencing considerable abuse by her husband. I advised her that giving up the tenancy might lead her to being found intentionally homeless. Now, you cannot be found intentionally homeless if you flee your property. This should be obvious, but this housing officer, obviously didn't know this or whatever. So yeah, went back and got a house a month or two later. But yeah, if you're on the advocacy side, you're dealing with housing officers who probably haven't had no training. They have ridiculous caseloads. They're using inadequate templates to make these decisions. So yeah, it's often actually not very difficult to kind of realize why these decisions are fatally flawed. And then finally, I think this is the last thing we're doing. No, yeah, there's two more kind of things, but we're going to talk about acquiescence briefly, and then we're going to talk about very briefly about triggering a fresh application. So I think we're actually doing all right for time. So acquiescence, as I say, fancy word. I said at the beginning that there is no such thing as an intentionally homeless family, and that other adults in the household can apply in their own name, and that usually the burden of proof of intentional homelessness is on the council. That it's the council's job to prove that you are intentionally homeless, with this exception. And the exception is where other household members can legitimately be assumed to know and have acquiesced in their other household members' intentional actions. So I'll go to this case first, just kind of paint a bit of a picture and then go into a bit more detail. So Nottingham XP Kane. This was a situation where they might have had kids as well, actually, but there's a couple, and the landlord was obviously a rogue landlord, hadn't fixed the property. There was kind of serious issues with it in terms of like there's no hot water. And so the guy basically said, right, I'm not going to pay my landlord rent until they fix these issues. And the landlord just evicted them basically. And the guy made a homeless application, and he was found to have become intentionally homeless because he'd willfully and persistently refused to pay the rent. And so his wife then made an application in her name, and essentially the council were at liberty to assume that as a couple they lived in the same household, they would have known what each other were doing, and the wife had not tried to stop the guy doing it, and therefore she was also found intentionally homeless, even though it wasn't her actions that actually led to the homelessness, but she had acquiesced in her husband's behaviour. As I said at the start, there's a lot of cases I think we would probably look at with different eyes now in terms of domestic abuse and stuff being in there. But as I say, at the moment, this is what the law is. So moving, kind of building on what we see from this Kane case, we actually go back to the BT case. We've actually talked about it already. But where you have in this case, a couple, and the wife basically said, I tried to stop my husband doing whatever he did that got us evicted. In that situation, the council need to provide a good reason for departing from the wife's account. So again, a lot of people are used to councils just being very unfair with the way they consider information. But actually, if you're in that situation where you're making an application, having had a household member already make an application, then and you say, look, and you provide some kind of credible account of why it was you didn't acquiesce in that behaviour, then unless the council's got a good reason to dismiss you, then that's actually a defence against having been found to have acquiesced in it. This case makes the point quite nicely here. So let me I'm not going to go off on too much of a tangent here. This was a situation where, again, same situation, couple, guy gets found intentionally homeless, and it seems, the guy was acting very unreasonably, but the woman was actually, trying her best to be sensible. And the judge made the point here that, in one sense, you don't throw the baby out with the bathwater. Just because the guy is going to end up getting support when he probably doesn't deserve it is not a reason to withhold support from the wife who does deserve it. I mean, it deserves a problematic word to use in this situation, but and I've seen this a lot of situations where it can really sometimes stick in your throat. I'll tell you a bit about a case I'm currently vaguely involved in, where the one of the household members has basically stamped their foot, refused any accommodation that doesn't have a garden. There's no particularly good reason for that, and so has been found intentionally homeless eventually. And then the another household member is making an application in their name, and they genuinely weren't part of the other, that first household member's behaviour. And in that situation, everyone's kind of a bit annoyed because this person's going to get what they want at the end of it. That is not actually something which is a real consideration you should be applying. Ultimately, again, the job is to apply the law, and because this other household member should be getting the help because they're eligible for it, that the fact that this other household member is going to get the help when they probably don't deserve it is not relevant. Hopefully that made sense. That was a bit of a waffle. And then finally, these two cases are interesting to compare side by side. Both are situations where there was a single mum, teenage children, causing a lot of antisocial behaviour. In the first case, Devonport v Salford, effectively the mum, although she wasn't doing the antisocial behaviour on the estate, she did nothing to control the behaviour of the boys, and so she was found to have acquiesced in that behaviour. Whereas in the Griffith case, the mum, there was evidence that the mum had tried her best to try and stop the kids being absolute nightmares. Hadn't worked. They ended up getting evicted anyway, but she was not seen to have acquiesced in that behaviour. Therefore, she wasn't intentionally homeless. This idea of household members making applications, I'll give you an example where, one example of many I've seen that really comes in handy. I worked with a family a few years ago, quite a few years ago now, where mum and three kids. Yeah, the oldest kid is over 18. The mum has a heart attack, goes to hospital. Whilst in hospital, housing benefit write to her and say, we did this information. She's in hospital, so she doesn't respond to it. Housing benefit stops. Council, the landlord then evicts them. And 5 months later, they come to me for support, which is obviously past that 21-day limit. I could have tried to make a fresh application and kind of find some new information, but in that situation, it was far easier just to make an application in the adult son's name. And he, because they weren't in, she wasn't intentionally homeless in the first place, but because of the way of kind of just triggering a fresh application, it was just a way to get around that resistance from the council. And ultimately, the whole household were owed the main duty. So that's kind of how it can be used to get a fair result in the real world. So finally, what do you do if you actually are intentionally homeless? So there's probably more. This probably list isn't very exhaustive, but there are some other things. Yeah, these are things you can always do. Firstly, is that where there are kids in the household, the housing department have a duty to duty to try and get the consent of the parents to then refer to children's services. Then the parents don't have to give consent. I'm not quite sure what happens if they don't, and that child ends up being homeless. But yeah, so generally speaking, at the point of being found intentionally homeless, there'll be a referral to children's services. Why children's social workers don't get training on intentional homelessness is beyond me, because there are loads of referrals made when the family is not actually intentionally homeless at all. And actually, children's services then get lumbered with this case where they're not housing professionals. They don't have any housing, and yet they have to try and house the family. So in that situation, if you ever know any children's social workers, they should get training on basic kind of this sort of stuff, really, because there are many cases where the family won't be intentionally homeless, and actually the kind of sensible way forward there is to challenge the intentional decision and get it overturned so that the duty goes back to housing. But yeah, children's services can often act as a safety net for situations like that. If they don't have kids, often the best option is going to be to approach supported accommodation, which can be problematic. I've said already that if you're not intentionally homeless when you go into supported accommodation, you probably are when you come out, just because of the way it works. Interestingly, if you guys have been keeping track of the Supported Housing Act, there is a condition in there which basically says if the support offered by the supported accommodation isn't up to scratch, then that person can't be found intentionally homeless, although we're yet to see the detail of what that looks like. They're working on it at the moment. or you have to go and approach slum landlord type accommodation because you haven't got any options. Or interestingly, you can apply to a different council, and this is still technically possible, or technically could be worth your while post Homelessness Reduction Act. So Jan Luber, whose book is in my car at the moment because I was reading it this morning, he recommends, if recommends is the right word, he basically makes the point that someone who's found intentionally homeless by Council A should go to Council B and see what happens. Because actually, what can happen is Council B find that you're not intentionally homeless after all, refer you back to Council A, who are then bound by Council B's decision. And we saw that in this case here, Slough XP Ealing, where a couple of households were found intentionally homeless by Slough. One of them ended up applying to Ealing. Ealing accepted the application, found that they weren't intentionally homeless after all. There was a bit of suspicion with that decision, but it is what it is. And then referred back to Slough, and Slough kicked and screamed about it, but actually ultimately they had to house the family because they were bound by Ealing's decision. As I say, post Homelessness Reduction Act, it's slightly different because of the way local connection now works, but technically it's still possible. And I mentioned it right at the beginning, you still do get reasonable preference on the housing register, but you're going to be in the lowest band. So unless you're in a kind of very low demand area for housing, you're unlikely to get housed that way, but it is technically possible. So yeah, any questions on any of that so far? If they approach you after the 21-day appeal period, e.g. 2 to 3 months, what can you do? Right, okay, we can answer that question here. So common problem, people approach the council, they get given an intentional decision, and then, yeah, as I said already, the kind of the time is ticking, then you need to get a challenge in. Now, this case happened earlier this year, is an example of a way in which you can trigger a fresh application. And it might be worth going into a little bit of detail here. So Miss Ivory, Sian Ivory, I think was her name, she had settled accommodation 8 years before, and she'd already told the council, I lost that accommodation because I had a mental health breakdown in some way, I'm not quite sure the detail. And Welling Hatfield said, no, that's not good enough, basically. So they basically found her intentionally homeless. And the question then was, would this new psychiatrist report be enough to be new information which could trigger a fresh application? So this Dr. Oken Rocha, he or she basically carried out an in-depth assessment with Miss Ivory and said that on the balance of probabilities, although it was 8 years ago, on the balance of probabilities, they believed that Miss Ivory had genuinely had a mental health breakdown and therefore wasn't able to manage the accommodation and therefore should not be found intentionally homeless. Welling weren't very happy about this, but ultimately, uh, this new this new medical assessment, even though it was 8 years out of date, so to speak, was enough to trigger a fresh application. Now, in that case, we don't actually know what the ultimate decision was, although the judge did say that Mr. Trerick, the review officer, should not be involved in the next stage of the decision-making process because the judge felt that maybe that housing officer would be jaded by the experience. So yeah, going to kind of the question there about, what do you do if you go over that 21-day appeal period? Well, the answer is, first of all, you try and find some new information, which is significant. I'll give you an example of a case I worked on a few years ago where a lady had pretty considerable drug and alcohol issues, polysubstance use, kind of really not in a good way. Made the homeless application to a council. They found her intentionally homeless, but they didn't consider her drug and alcohol use. So a bit like that Kendall case in some ways. 9 months later, she then gets referred to me, and I basically ultimately I used the fact that there was this kind of assessed substance misuse issue. I think actually, if I remember correctly, I went to the drug and alcohol team that was supporting her and just got evidence that she had drug and alcohol problems at the time that she was evicted, which they could do because they were working with her at the time and had a lot of detail actually. And I used that to trigger the fresh application, and ultimately she was owed the main duty. So, Will, I don't know if there's anything else that you would suggest around kind of out of time review requests, because I know there are some situations where, for example, someone's in real chaos, and you kind of say, well, look, the person wasn't in a position to actually review at the time anyway. But yeah, have you got anything else to add to that at all?
No, not really. I mean, it's always worth asking. I mean, the problem is if they refuse, it's pretty difficult to challenge it. So what I would normally do is ask them to carry out a review out of time and then say, in the alternative, if you don't want to do that, can you accept a fresh application? And then they might think, oh, we'll just do a review because it's less hassle than processing a fresh application. But they might say, no, we're not going to do a review out of time, and we don't think you've triggered a fresh application, so get lost. It has happened to me, and I wasn't able to challenge either at the time, but you would then fall back on. Remember the fact that if somebody's intentionally homeless, the odds are they were in priority need because they wouldn't have got round to thinking about that. So you can always then fall back on the Section 190 duty, which is real, and they do have a duty to assist. And if they just say no, here's some leaflets, you could look into then challenging them legally if they're not giving accommodation because there's a power to accommodate while they're providing the assistance under Section 190.
Yep.
So that's what I would add.
I mean the Ivory case kind of makes the point that when you are trying to trigger a fresh application to kind of kind of get everything in play again, the change in relevant facts doesn't actually necessarily, you don't need to show that there might be a different result with the ultimate decision. You just need to say that you show that there's a change in facts of some kind. And again, there's a more detail to this. I'm kind of maybe kind of oversimplifying it. But in that Ivory case, they said, unless the facts are trivial, as in, and it gives the example, about the day of the week the application was made or the method by which the application was triggered. So, first time you did it via email, second time you did it by phone. If those would be trivial kind of facts, but anything more substantive than that should be treated as a fresh application. Now, it may result in the same ultimate decision of the person being intentionally homeless, but we work with people in crisis. Getting someone 3 months worth of accommodation under Section 188 and then Section 190 may well give us the chance to then engage with that person and get a better outcome. So, yeah, I mean, I think the reason I'm kind of making a point in these slides is that, in my experience, housing law generally has some kind of avenue you can go down to try and get someone, a roof over their head, even if it's just for the short term. And that can be a key kind of point to kind of to engage with them, to kind of show that you're actually serious about trying to support them, and maybe get a different outcome from the previous application. So yeah, that brings us to the end of the slides. I'll put a few bits in the chat for anyone interested. So if you haven't subscribed to the YouTube channel, feel free. You'll get notifications of new videos, including the weekly live stream. So if you have questions, feel free to email me, but I probably won't respond to you in writing. I will probably take it to the next live stream to discuss it properly there. Also, there's a Facebook group we run, which basically gives people space to ask what if questions. You'll get a pretty quick response when you do that. And if you're interested in more webinars like this, follow us on Eventbrite and you'll get notifications when new events go up.